All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Demetris Benson. Demetris Turner Benson. Wyatt Berkwin. Wyatt Lane Berkwin. Ms. Abraham. Krista Hastings. Krista Levon Hastings. All right, today is August 13th, 2024, Tuesday, correct? Is this the Tuesday docket? We haven't gone 0 for 3 in our first 3 at bats in a long time. Berkwin? Okay. All right, thank you. All right, that makes me feel better. Fernando Hernandez. Kyle Holland. Belinda Norman. Belinda Norman. Okay. Adriana Jacobs. Max Juarez. Isaiah Rosser.
Here.
Ian Gray. It's Mr. Gray here. Court granted Ms. Brummelow's motion for continuance and set pretrial on September 24th. However, I did order, Ms. Abraham, did you include that language on the order for the court? Court did order Mr. Gray to appear and sign a notice of appearance and to check in with pretrial release. He just checked in? You saw him? Okay. All right, court has granted the continuance and set pretrial September 24th. And Deputy Martinez says that Mr. Gray did check in with the court this morning. Bennett Watts, CR 24157, set for arraignment. Mr. Harrison filed a waiver of arraignment that was approved by the court. Pretrial set September 24th. Juan Wilkins. All right, and Mr. Lewis, counsel for Mr. Wilkins, is present in the Zoom courtroom and will be admitted shortly. Robert Bradley. Drake Andrews. Elizabeth Black. Darian Dotson. Court has received information that Mr. Dotson's experiencing car troubles. The court will recall Mr. Dotson's case this morning. Donald Allen Ellis. Jay Harrison. Jay Harrison, okay. Dallas Hightower. All right, we'll recall his case. Andrew Holden. Andrew Wayne Holden. Gerald Holmes. Jeremiah Holmes. Harold Morgan. Evan Page. Nathaniel Potter. Michael Powell. I believe that Mr. Powell may still be in Wood County custody. All right. Court will recall Mr. Powell's case. Amanda Reyes. Haley Smith Arndt. Robert Wells. Amanda Wellborn. Aaron Ross. Curtis Smith. Jesse St. John. Tammy Jones.
Your Honor, Ms. Jones was out already.
Thank you, Mr. White. Obed Mingastu.
Your Honor, last I checked, I talked with his mother, and then I also verified that he is in Dallas County Jail, he's been there for some time.
All right, we'll call that a little bit later then. Jeremy Treadway. All right, do we have any counsel that's ready? Mr. White, you ready? You don't have to be ready. I just give you that opportunity. Who do you want to call Curtis Smith or Curtis Wayne Smith? All right, Mr. Smith is set for docket call today, cause number CR 24, 64, and 65. Go ahead, Mr. White.
Your Honor, we are going to be asking for about 30 days, and we'll probably have a resolution at that time. Part of the reason is we are looking at a different rehab than originally was offered. And we want to be able to get some information to the state so that they can have a chance to check it out. If we have about 30 days, we'll be able to get this resolved. No, okay, we'll find out.
September 24th, Mr. White.
Is that a Tuesday?
Yes, sir. Tuesday.
Let's try it Thursday. If you got it.
October 3rd.
Third sounds great.
All right, court sets Curtis Wayne Smith for a final docket call October 3rd at 9 a.m. Once he signs, he's free to go. You ready on Mr. Ross?
Yes.
Aaron Ross? Mr. Ross, go back and then come across. Perfect. No, that's fine right here. The front row is fine. You can go, just don't walk don't walk past that first bench. There you go. Not a problem. All right, this is cause number CR 24-43, State of Texas versus Aaron and Logan Ross. Also cause number CR 2444. I believe that we're set for docket call in each case. Go ahead, Mr. White.
It's going to be there. At 30 days. Get all that.
Do you want that same October 3rd date?
Could we make that actually a little bit earlier? If we could do it in September?
I can put you on the evidentiary docket on September 26th. I mean, I have some dates in August still.
We could do it.
Would you rather do August?
Yeah.
How about so I either got Tuesday, August 27th or Thursday, August 29th?
22nd.
No, 27th.
27th.
Now that's a Tuesday.
But it's not Monday night football.
I don't know. I don't think they played Monday Night Football on Tuesdays, so somebody may still be playing football on Tuesday. I'm not sure. All right.
27th.
August 27th for plea. You're welcome. Free to go. You ready on Jesse St. John? Jesse St. John? All right, Mr. St. John is set for docket call on cause number CR 2436. Go ahead, Mr. White.
Your Honor, we just need this to be set for.
You want the earlier or the latter? You want that October 3rd or September? All right, court sets Mr. St. John for plea October 3rd. Is that a morning plea or afternoon plea? All right, 9 a.m.
That's all I've got.
Thank you, Mr. White. Mr. Mills, you ready?
That's what I'm waiting on the paperwork.
Okay.
Yeah, we've got it worked out.
Okay, good. Kyle Holland. All right, this is a sanctions court hearing in cause number CR 2291 for Kyle James Holland. Let's see, Mr. Holland, last time we had you in sanctions court, we ordered you to do a few things. One of those being work 20 hours community service. I see that you completed that. You were to pay court cost of 125. You complied with that. And then you were ordered to pay $60 to probation. I think you paid that incorrectly to the district clerk. Is that correct?
Correct. Yes, sir. I picked it up in court. Then I would be paid yesterday.
Very well, very well. Okay, how are things going with you?
Good.
Yeah, how's business? Business good? Yeah. Where did you do your community service?
Here at first, one thing.
Okay. Did you do 20 or did you do more than 20?
This one.
Did 20,
I'm sorry. They give me credit.
30. Okay, good. All right, Mr. Holland, do you have any questions or any issues that we need to talk about?
Sorry.
All right, court will reset you for an additional sanctions court hearing. We need $60 to probation, $100 towards your court collections, 20 hours community service, and I want you to continue in your what's IOP? What's IOP again? And you got to continue in your intensive outpatient program in Dallas County. I want that to continue to be successful, okay?
Yes, sir.
And we're going to come back on September 24th at 9 a.m. And make sure you turn those things in by Friday of the week before court. All right. So the preceding Friday by noon, turn all that stuff in. Isaiah Rosser. All right, this is also sanctions court hearing CR 21239. Let's see, Mr. Rosser. Last time was your first time in sanctions court, correct? This is your second hearing. And I believe at the last sanctions hearing, we discussed some goals for you. One of them to be pay your probation fee. I see you took care of that. Pay your UA fees. You took care of that. Work 25 hours community service. You took care of that. Where did you do your community service? Where was that at? What'd you do for him?
We have, that's not.
Okay, good. It looks like the only thing that you came up short in was court cost payments. You ordered to do 150, you paid 100. Did you just not have the extra 50?
Also, I have paid this day, I have stuff, paid, probation 150, and paid, district court, but I paid this, I haven't received.
I'm gonna take you at your word. Okay. All right, so Mr. Rosser, I want to bring you back on 9/24 and 75 to probation, 150 to your court costs, and 25 hours community service. Kind of the same thing that you did last time. You said you paid your UA fees, you don't have to worry about that. And just a reminder, you're paying these increased fees because we have to try to get you back on track so that you can expire on time. So if you will give me several months of compliance in a row, and I see that you're taking care of business, then I'll be able to take you out of sanctions court and let you just go back to regular probation. Okay. All right. So we'll see you back on 9/24. We've got a notice of appearance you're going to sign, 75 to probation, 150 to court collections, and 25 hours community service. Okay. Max Juarez. All right, Mr. Juarez, this is a sanctions court hearing in cause number CR 23-185. This is your first time in sanctions court, is that correct? All right, here, I'm going to read you some notes that I have, okay? Just so you understand what I'm reading. It says defendant has not started his conditions of probation after being referred for drug offender education program in community service restitution by Henderson County probation officer. Defendant did not take his substance abuse evaluation until after he was placed in sanctions court. Defendant has not made any payments to Van Zandt County probation or to the district court. It looks like you were put on probation this year in January for 3 years on a state jail possession of drugs, and you're on deferred, meaning you've not been convicted of this offense yet. So do you disagree with those notes?
I did talk about because I was been short on money coming from my mainly. I'll be everything paid within these 2 weeks on the probation fee, everything else, and then thank you for everything. My community services, I just did working Monday to Saturday night. I haven't really had time, but I'll get it. I'll tell my boss I need to read it off and everything, so I can get that done. So, for sure.
Yeah, because every month that you don't do community service, you just fall behind, and that community service doesn't go away. It just adds up. It gets to be a larger amount each month.
They let me, since I'm working here, full time, they let me get some hours off of that, but I'll come in. I say, we come in Henderson County, but I'll try to transfer over here because I don't have a phone.
Are you on just being supervised in Henderson, or are you also on probation in Henderson? Whatever hours you're doing over there, those hours are not going to apply over here. Yeah.
Transfer over here, where now I'll find the right over here.
Is that right or wrong? Does he get concurrent credit on both cases? Not, huh? Yeah, not to his case. Okay. So what the probation department's telling me is you either do community service for them and get credit there, or if you do community service over there and they transfer those hours over here, you get credit here, but not over there.
Okay, yeah, that's fine. I'll put it tight, so they give me credit for working sometime, but it'll be better if I do it on the weekend. Come over here.
All right, well, make sure you talk to both probation departments and get that worked out. All right. All right, I'm going to reset you, Mr. Juarez, for September 24th, and I'm going to give you several things that you've got to do. All right. I need you to pay $90 to probation. All right. And then we're trying to get you caught up. We're not trying to take more money from you. We're trying to get you back on track for the past payments. I need you to pay $75 to court collections. All right. I need 15 hours community service. I need you to comply with the 12-step program. And you said that you've already enrolled in the drug offender course. Okay, then I just need you to give proof of that to the probation department here. Okay, so those are 5 things that I'm gonna need done. And you're gonna come back to court on September 24th. I need you to have all those things turned in the Friday before by noon. All right, so I'll tell those things to you again. We wrote them down for you, but $90 to probation, $75 to court collections, 15 hours community service, comply with your 12-step program, and show proof of your enrollment in drug offender. Free to go. Adriana Jacobs or Adriana Jacobs. Cause number CR 24-101. All right, Ms. Jacobs, I see that you've been indicted for the 2nd-degree felony offense of burglary of a habitation. That does carry a range of punishment if you were to be convicted and sentenced to not less than 2 years in prison or more than 20 years in prison, and a fine not to exceed $10,000. Do you intend to hire an attorney, or are you requesting a court-appointed attorney? Okay, have you filled out that paperwork yet? All right, Ms. Tabraham, this is Miss Adriana Jacobs, and she's requesting a court-appointed attorney. She'll get you the paperwork, so just go have a seat in the hallway, and she'll bring that paperwork to you. I couldn't hear you. Juan Wilkins. All right, Mr. Wilkins, I'm bringing your attorney in on Zoom this time.
Morning, Judge.
Good morning, Mr. Lewis. Can you see and hear me okay?
I can. My apologies for the delay.
Hey, no problem. I have your client, Mr. Juan Wilkins, present in the courtroom. Can you see him as well? He's at the podiums.
I can, Judge.
All right, Mr. Wilkins, can you see your attorney? Okay, excellent. All right, this is cause number CR 24-123, State of Texas versus Juan Miguel Wilkins. We're set for pretrial today. Do you have any contested pretrial motions on file, Mr. Lewis?
I do not, Judge.
All right, do you expect any to be filed?
Yes, Judge. I still have not received discovery at this point. We submitted a 3914 probably about a month ago, so I'm still awaiting that.
So you don't have any discovery?
I do not, Judge.
Okay, state, any announcements on that?
Your Honor, just a minute, I want to make sure that I have this correct.
While the state is looking at that, Mr. Lewis, did you request, you said you requested that, was that by letter, email, or how did you communicate with the DA's office?
That was my letter, Judge.
By letter.
Yes, Your Honor. So instructions to get set up in the portal were sent to Mr. Lewis. He has not followed through with getting set up in the portal, so we are unable to send him discovery until he follows through with that.
When was that sent and where was that sent?
Your Honor, I checked with Ms. Melton on the 7th, and she confirmed that he had not. I'm not 100% sure when it was originally sent out to him.
Did you receive anything to that nature, Mr. Lewis?
Judge, I don't believe so, but I'm not denying that it was not sent. So I will have to go back, I guess, and figure out where it was sent and follow up on that. My apologies if it was sent.
All right. Go ahead, Mr. Hartwell.
Ms. Melton is there now, and she can help get that set up, and we can get that to you today.
Did you hear that, Mr. Lewis?
I did not. I'm sorry, Judge. I didn't hear the end of that.
Mr. Hartwell said that the prosecutor, Mr. Hartwell, said that if you'll go ahead and contact the Van Zandt County Criminal District Attorney's Office today and ask for Miss Melton, she can take your information and get you set up and get that released to you. But you will have to fill out their online setup so that they can release all that information to the appropriate email and what have you.
That will be happening today, Judge.
All right, so what I'm going to do is I'm going to reset today's pretrial for September 24th. And of course, according to the code, any contested pretrial matters, pretrial motions will need to be filed 7 days prior to that date.
Thank you, Your Honor.
So that'd be September 24th at 9 a.m. And I'm going to have your client, Mr. Wilkins, sign a notice of appearance, and that'll be filed with the court.
Thank you, Judge.
You're welcome. Thank you, Mr. Lewis.
Well.
You're welcome, sir. Still waiting on paperwork. Yeah. This is on Mr. Bradley. All right, Mr. Bradley. All right, this is cause numbers CR 15-176, CR 16-233, State of Texas versus Robert Lynn Bradley. Mr. Bradley, sir, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thanks, sir. You can lower your hand. Make sure you speak up loudly and clearly. Court reporter's got to take down what you say, okay? All right, Mr. Bradley, you're here today on the state's motions to revoke filed in your case. And it appears to the court. Let me see. Did the state not produce the motions to revoke, or do you have those, Mr. Mills?
Judge, we received those actually several years ago, but I didn't see it in the paperwork there. And I didn't know about it.
Can you produce those, Mr. Hurwell?
I received a copy of it.
All right, Mr. Bradley, and cause number CR 15-176, the state filed a motion to revoke your community supervision on May 29th, 2018. And in that motion, they alleged one single count of an alleged violation. And also in cause number CR 16-233, the state filed a motion to revoke in that case also on May 29th, 2018. And they alleged a single count in that motion as well. Have you had enough time to review these motions with your attorney, Mr. Mills? You feel like you've had enough time to discuss the cases with him, that you've had all of your legal questions answered, and that you're pleased with the services he's given you? All right, Mr. Mills, do you believe Mr. Bradley to be competent?
Yes.
And does he waive the formal reading of the state's motion to revoke in each case?
Yes.
Does he intend to plead true to each count? All right, Mr. Bradley, and cause number CR 15176. How do you plead to count one? Is that count true or not true? And in cause number CR 16233, as to the count one in the motion, is that count true or not true? And Mr. Bradley, has anybody threatened or forced you to plead true to either one of these counts? All right, the court will accept the defendant's plea of true to each count as alleged. Mr. Mills, any objection to the admission of a defendant's waiver of rights and plea of true in evidence? All right, that is admitted in each case. The court does take judicial notice of the defendant's judicial confession. Is there anything further from the state? Anything further from the defense? All right, Mr. Bradley, I do see that there are agreements between you and the state in each one of your cases, and they appear to be identical. However, there are some differences with regards to financial obligations, fines, court costs, restitution. But the plea agreement appears to be that upon the court accepting your plea of true and following the recommendation of the state that your community supervision would be revoked today, that your punishment would be assessed under section 1244A as a class A misdemeanor punishment at 270 days confinement in the Van Zandt County Jail, with you receiving credit for 365 days with a balance of your financial obligations. The state's recommending to the court that they're not opposed to you receiving credit towards the remainder of your financial obligations at a rate of $50 per day. That's in each case. I see that you do have financial obligations in CR 15176 of $1,000 fine, $63 in court cost, and restitution in the amount of $2,050. That restitution being owed to Glenn Boren in Irving. In cause number CR 16233, your financial obligations are $1,000 fine, $53 court cost, restitution in the amount of $1,120.45 payable to the estate of Ted Stillwell in Eustis. Is that your understanding of the plea agreement? And before I go any further, Mr. Mills, I understand the state's recommendation of him receiving credit towards court costs and fine for days that he has spent in jail. Tell the court as to how Mr. Bradley ended up in jail and why he should receive credit towards his financial obligations.
I would just tell the court, I think he has actually more than 365 days in this jail. I think or longer than that. I can tell the court back when the party came up, maybe back in 18 or 19. Mr. Bradley had cancer and diagnosed with cancer before back and forth. That was pretty much. And that's why this finger so long to come back up. So he's not been in dire straits in the last 30 years. The people of his money, they're having to back and forth now. 3 months. Back over a year. Reason the press.
And did he abscond from jurisdiction? Is that why these are old cases?
No, Judge, when the DA's office filed on the back in 18, he was in jail. Our representative back here came over here, and I think, not sure what prosecutor I thought did, but at any rate, the motion's not all being dismissed at that time, the current petition put on hold. But, some know he's not, I can represent Bradley on civil matter and other things in the last 10 years, so I think he may, I don't think he was not at all.
And so was he in jail on this allegation alleged in count one as
He was for a period of time, maybe, I think that's something that happened in Henderson County, I want to say, and I think that case was either dismissed or finally got to both away from what happened that day.
You mentioned that he was in jail. What was he in jail for if it was not this case or the counts alleged?
Yes, he had a warrant for this, and they turned himself in Henderson County on this warrant. So he made them a general action period of time, this warrant, before he got brought back. It doesn't have to be here, right? But he was in jail here a year for a file, I guess. That's when he got the county, that's when he got, and he was out. The ball went off here, he turned himself to Henderson County. Like this how it played out. But then I guess he bought it out, he went back to the house.
Is he in remission on his cancer? And is he working now? And is that disability related to your cancer? And does your client understand that restitution cannot be given credit for jail time? All right, then in cause number CR 15176, the court finds that Robert Lynn Bradley has violated the terms and conditions of his community supervision. The court will follow the plea agreement this day. The court revokes his community supervision, assesses his punishment under section 1244A at 270 days confinement in the Van Zandt County Jail. The court will give him credit for 365 days of time already served. Court orders him to pay the balance of his financial obligations. However, the court will grant Mr. Bradley credit towards his remaining financial obligations. Mr. Hartwell, I think the recommendation was $50 a day, but I think the law provides it's $100 a day. Is this a retroactive application from like 2018, 19, or whenever he was in jail? Or because I believe that the law is $100 a day for incarceration.
And Your Honor, we may have misunderstood. We thought it was 100 for the jail period, giving 2-for-1 credit. Otherwise, it's 50, but we may have misunderstood.
Okay. All right, the court will grant Mr. Bradley $100 per day credit for any time spent in jail over 270 days towards his financial obligations, which includes fine and court costs. Court does not grant, nor can it grant any credit towards restitution. Restitution is owed in the amount of $2,050 to the victim as identified in the judgment. In cause number CR 16233, the court accepts the defendant's plea of true, finds that he has violated the terms and conditions of his community supervision. Court will follow the plea agreement this day. The court revokes Mr. Bradley's community supervision, assesses his punishment at 270 days confinement in the Van Zandt County Jail pursuant to section 1244A. The court awards him credit of 365 days towards that 270-day sentence. Court will order him to pay the balance of his financial obligations, but does grant him $100 per day credit for any time spent in jail over 270 days towards his financial obligations. Court orders him to pay restitution in the amount of $1,120.45 to the estate of Ted Stillwell, the victim identified in the judgment. And since these are 1244As, I'm just going to mark through the judgment that where it says 50 and put 100. Any objections?
No.
All right, Mr. Bradley, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted. And if you need copies of these documents for your records, the probation officer can help. Yes, thank you, Mr. Bradley. All right, the court's going to stand in recess, allow Mr. White, Mr. Schmidt time to meet with their clients. And if the state will just notify Ms. Taberham when we've got sufficient pleas ready to go and announcements, and then we'll proceed. All right, court's going to stand in recess. You're free to walk about the courthouse and just be within earshot. It's probably going to be 20-30 minutes before we start back. All right, so you're welcome to walk outside and check back in. Court's in recess. All right, we are back on record on the criminal docket. Mr. Schmidt, are you ready? Who would you like to call first? Ms. Jacobs? All right. Well, let's move on. We'll call someone else. Mr. Berkman? All right, this is cause number CR 24-128, State of Texas versus Wyatt Lane Berkman for arraignment. The court finding Mr. Berkman to be indigent and having requested court-appointed counsel. Court has appointed the Honorable Richard Schmidt. Mr. Schmidt, I think the court's provided you with a copy of the indictment. Are you ready for arraignment?
Yes.
All right, court will find Mr. Berkman has waived the formal requirements of arraignment. The court enters his plea of not guilty into the record, and the court sets this matter for pretrial hearing. You available on September 24th, or do you think you need more time? What about October 1st? Oh, yeah. All right, October 15th at 9 a.m. And has Mr. Berkman signed his conditions of pretrial release?
Yeah.
All right, thank you. Fernando David Hernandez, CR 23-162. All right, Mr. Hernandez, having requested court-appointed counsel, the court finds him to be indigent, has appointed the Honorable Richard Schmidt. Mr. Hernandez, I think we've provided you both with a copy of the indictment. Are you ready for arraignment? Go ahead. All right, court enters his plea of not guilty into the record, sets pretrial on October 15th at 9 a.m. Mr. Hernandez, because you were arrested outside of Van Zandt County, they do not have your fingerprints that they are required to report to the state. So I'm going to bring you this order here. What I need you to do after court is I need you to go out to the Van Zandt County Justice Center, show them that order. They're going to take you back and just take your fingerprints. It may take a few moments for them to do that. Be patient with them, but they have to get that reported to the state. So I want you to do that after you leave court today, okay? All right, make sure you take that order along with the photo ID. All right, thank you, sir. Who's next? What was her last name again, Mr. Schmidt?
Again?
What was her name? Wellborn. Okay, sorry. All right, this is cause number CR 24-122, State versus Amanda Marie Wellborn for pretrial. Go ahead, Mr. Schmidt. All right, court finding no contested pretrial motion sets this matter for docket call October 15th, 9 a.m. Ms. Wellborn, I show that you're delinquent on your pretrial release. Have you made a payment recently? Okay, so when I ask you if you've paid, just, yeah, you tell me, yes, you paid. So $60 yesterday, I show that that's what you were delinquent. So I'm just making sure that you're staying in compliance. And so you did pay $60 yesterday to pretrial release. You're looking like you're unsure. Yes. Okay, all right. That's all I wanted to know. Ready to go. October 15th. Who's next? Haley Smith Arndt, CR 24150. All right, I believe that Ms. Smith Arndt is set for arraignment today. Are you ready for arraignment? Go ahead. All right, court, finding that she has waived the formal requirements of arraignment, enters her plea of not guilty into the record and sets this matter for pretrial on October 15th. Once she signs, she's free to go. Amanda Reyes, CR 24108. All right, Ms. Reyes is set for pretrial. All right, the court enters, or the court finds that there are no pretrial settings, sets a docket call October 15th at 9 a.m. I show that Ms. Reyes is delinquent $70 on a pretrial release. Did she make a payment towards that? Okay, how much are you going to pay tomorrow? Okay, all right. I'm just going to note that down. $60 tomorrow, correct? All right, thank you. I just forgot. It was on there and I forgot about it. All right. This is cause number CR 19-63, State versus Evan Andrew Page for docket call. Go ahead, Mr. Schmidt. State. All right, court will set a final docket call October 15th at 9 a.m. Mr. Schmidt, there's several concerns written on my docket. It says that Mr. Page has not reported in May, June, or July on pretrial release, and he's delinquent $240. Yes. All right, in Mr. Page's case, the court is going to set him for docket call on October 29th instead of the 15th, October 29th. And Mr. Page, after you're dismissed, I want you to come over here and meet with Mr. West and Miss Burns and discuss your other issues that you have going on in the other jurisdictions, so they understand the issues with your pretrial delinquency. All right. Who are you ready on next? Harold James Morgan. CR 24-105, CR 24-159. Mr. Morgan is set for pretrial, and then in 159 set for arraignment. Let's go ahead and do the arraignment. We're set for pretrial. Let's go ahead and arraign him, and then we'll do the pretrial.
He's like, doesn't I do? I checked instead of yesterday, he said, I think that, last time. I submitted the waiver, I had in my possession, so I'll be standing there. So we're ready.
Yes, yeah, I'm saying let's go ahead and arraign him on the new one, and then we'll set him for both for pretrial. All right, court enters Mr. Morgan's plea of not guilty in cause number CR 24-159. Finds that he's waived the formal requirements of arraignment. Court will set both cases for pretrial on October 1st. I'm sorry, October 15th. Ready to go. Who would you like next? J. Randall Harrison, cause numbers CR 24-137 and 138 for arraignment. In each case, go ahead, Mr. Schmidt. All right, the court enters Mr. Harrison's plea of not guilty into the record, sets us each matter for pretrial October 15th at 9 a.m. Ready to go. You're welcome. Donald Allen Ellis, CR 24-83. All right, Mr. Ellis is set for docket call. Is it just to consider the offer or any other issues? Any opposition to setting a final docket call October 15th? All right, court sets Mr. Ellis for a final docket call October 15th. And I show that Mr. Ellis is delinquent on his pretrial release fees by $60. Have you made a recent payment? All right, thank you, sir. Elizabeth Diane Black, CR 24-91. Ms. Black is set for a pretrial. All right, court sets for docket call October 15th at 9 a.m. Also show that Ms. Black is delinquent $60 on a pretrial. Ms. Black, have you paid? All right, the full amount. Thank you. All right, this is cause number CR 24-107, State of Texas versus Nathaniel Warren Clay Potter. Mr. Potter, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Thanks, sir. You can lower your hand. All right, I see that we have a plea in this case. Mr. Potter, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes.
Do you understand everything that you've read and signed that's part of your plea agreement? And do you have any questions before we go further? Mr. Schmidt, do you believe Mr. Potter to be competent?
Yes, sir.
And do you believe that he's understood his rights and the waivers in this plea agreement that he's making here today?
Yes.
All right, Mr. Potter, you are charged by indictment with a third-degree felony offense of failure to comply with sex offender's duty to register. A third-degree felony does carry a range of punishment of not less than 2 years or more than 10 years confinement in prison. Also carries a possible fine not to exceed $10,000. I see that the plea agreement in your case, upon your plea of guilt, the state's recommending to the court that the court convict you of this offense, that the court assess your punishment today at 5 years in prison, but that the court suspend that sentence and place you on community supervision or probation for 3 years. In addition, that the court would assess a $2,000 fine plus $290 court costs, and also order you to reimburse Van Zandt County fees in the amount of $535. Is that your understanding also, Mr. Potter? All right, understanding the range of punishment and the plea agreement, Mr. Potter, how do you plead to that offense? Are you pleading guilty to that crime because you are in fact guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty? Court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence? All right, stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state? Anything further from the defense? All right. Court's going to consider the evidence. All right, based on the evidence presented, the court finds that there is sufficient evidence to convict the defendant. Court will follow the plea agreement. Today, the court convicts Nathaniel Warren Clay Potter of failure to comply with sex offender's duty to register a third-degree felony, assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice. The court suspends that sentence today and places Mr. Potter on 3 years of community supervision, orders him to pay a $2,000 fine, and court costs of $290. Further, the court orders him to pay reimbursement fees of $535. All right, Mr. Potter, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with the deputy. After that, the probation officers will give you more info. Mr. Andrews. This is cause number CR 24-89, State of Texas versus Drake Allen Andrews for pretrial. Go ahead, Mr. Schmidt.
No, I just think about this, and I think maybe like, we may end up needing a little bit longer from the issues are been required to hold and. But I would really think of another pre-trial.
And just so we're not vague, what are there issues that we can talk about? Are they confidential issues? Okay, no, that's okay. All right, court will grant Mr. Andrews an additional pretrial setting on October 15th at 9 a.m. And Mr. Andrews, I showed that you were due a delinquent $60 on your probation or your pretrial release fees. Have you paid that? All right, this Friday? All right, I'm gonna write that down. I'm gonna take you at your word, okay? Make sure that you pay that before noon because or can they pay that online afternoon? Paid online afternoon, or if you're gonna pay in person, you gotta be there before noon. Okay. Ms. Jacobs? This cause number CR 24-101, State versus Adriana Marie Jacobs for arraignment. Court finds today that Ms. Jacobs, having requested court-appointed counsel, finds her to be indigent, has appointed the Honorable Richard Schmidt to represent her. And are you ready for arraignment, Mr. Schmidt? All right, court finding that Ms. Jacobs has waived the formal requirements of arraignment, enters her plea of not guilty into the record, and the court does set this matter for pretrial on October 15th at 9 a.m. Dallas Hightower. This is cause number CR 23-217. Motion to vote. Go ahead, Mr. Schmidt. Yeah, I think we show Mr. Hightower to currently be set for August 27th. Well, 27th wouldn't be contested. So you want it on August 29th to contest the docket? All right, court sets Mr. Hightower for the evidentiary docket August 29th at 9 a.m. Be sure to take that out of LGS and it's at 827. So just bump it over. Way to go. Gerald Alexander Holmes. CR 24, 55, 56, and 57. Mr. Holmes set for docket call in each case. Go ahead, Mr. Schmidt.
Judge, and so all these, and,
Yes. Do you want that October 15th?
The later date. October, can I get a little?
29th?
Yes, sir. If I could.
Any objection, Mr. Harlan?
No objection.
All right, we're back on the record. Cause number CR 24 55 56 57, State of Texas versus Gerald Alexander Holmes. Court is granting the defendant's request to reset an additional docket call to October 29th. That'll be at 9 a.m. Mr. Holmes, once you sign your notice of appearance, I want you to come back here and meet with Ms. Burns and the pretrial release officer. And we're going to amend your conditions of pretrial release to ensure that you do not have any more GPS violations. We're gonna put some very specific addresses on there so that you know that you're not supposed to go anywhere within that. And so if you're riding with someone else and they're gonna go through that, then you're violating whether you're driving or not. So you need to make sure that you do everything you can to comply with the court's order. All right. Who's next, Mr. Smith? Mr. Holden. Cause number CR 24-100, State versus Andrew Wayne Holden for pretrial. All right, court sets Mr. Holden then for docket call on October 15th. I show that Mr. Holden's delinquent $60 on pretrial release. Have you made a payment recently? You can pay all 60 by Friday. All right, and Mr. Holden, you did not go to the jail and get your fingerprints like I told you to do the last time we were in court. Do you have it today? Do you have it today? All right, I'm gonna order you to do the same thing, okay? Here's another copy of that order. Okay, take your ID, take that order, and go out to the jail and let them get your fingerprints, okay? All right, we are back on the record, cause number CR 23-162, State versus Fernando David Hernandez. So, Mr. Hernandez, Mr. Smith's indicated that you do not have any type of picture ID. Which ocean did you lose it in? A big one. So you have any other picture ID? You have a ID, I mean, like was that a driver's license or just an ID? You have a social security card? Hmm. I can't hear what you're saying, but it probably wasn't funny. Yeah. Well, I don't know. I don't know how the jail's going to go about getting your fingerprints. Did they tell you that they have to have a picture ID? Where were you arrested at? All right, I can't really deal with this issue until I take a break, and I'm not gonna be able to take a break until lunchtime. So he can either go to the jail and they can try to walk him through it. But if I've got to deal with it, I won't be able to deal with it until we're done.
No, it's even with violating words.
Yeah, will you? Just go ahead and have a seat in the hallway when Deputy Martinez is gonna see what he can do about maybe possibly, this is what he's gonna try to do is he's aware of other counties that have been able to summons a picture of the ID from DPS, from a law enforcement agency to law enforcement agency. If they can do that, then that may suffice. So just have a seat in the hallway. Let's see what we find out. We'll be with you in a minute. All right, who's next? Jeremiah Holmes, CR 24-141. And Mr. Holmes is set for arraignment. All right, court finds Mr. Holmes having waived the formal requirements of arraignment, sets pretrial in this matter October 15th at 9 a.m. Once he signs his notice of appearance, free to go. Okay. So you just have what Wells and Powell will need to make an announcement. I know Powell's in Wood County, but we need to make an announcement on it. Sure, that's fine. She can just write it in. Karen can write it in. Yeah. They can? Yes. Okay. Did you tell Richard?
Him to go down there, check waiting to confirm it. So when they come to go down there, he'll tell the kid to go down.
Great, thank you. Thank you.
Yeah. Yeah. That would say, see attachment.
Who's next, Mr. Schmidt? You've got Mr. Wells. Robert Michael Wells, CR 17266. All right, Mr. Wells is set today on just a compliance hearing.
We would ask. Compliance here.
All right, and I'm gonna drug test Mr. Wells today. We'll reset Mr. Wells for October. Let's do 29th. Are we making any inroads on our community service? All right. All right, once you get your nose of setting, come back here and see Mr. West, and he'll take the hair follicle test, and then you're free to go. Yeah, let's announce on Michael Ray Powell, CR 24146, CR 24146. Court finds that Mr. Powell is still in custody in Wood County, I believe. So we'll reset for a status of custody for October 29th at 9 a.m. What about Darian Dotson? Is Mr. Dotson here? All right, so what I'll do is I will have his name called. If he doesn't answer before lunch, then I'll take the NISI under advisement throughout the afternoon, wait for more information. If I don't receive more information, then I may not take it under advisement past today. Right, I believe that concludes your morning docket. Mr. White, are you ready, sir?
Yes, sir, I am.
Who would you like to call first?
Let's call.
Treadway? Jeremy Lynn Treadway, CR 24-8 for docket call. You may. All right, the court sets Mr. Treadway for final docket call on September 24th at 9 a.m. And once he signs his notice of appearance, he's free to go. Let's go ahead and put Mr. Mingastu on the record. This is cause number CR 24-143. The court finds that Mr. Mingastu is in custody in Dallas County. He's there on over $440,000 in bonds, has, I think, 6 charges from sexual assault and human trafficking to numerous other things. So the court's going to reset this. Mr. Hartwell asked that you either get a hold of the state in Dallas to find out when we might possibly take him if you are indeed still pursuing your possession of controlled substance and penalty group 2, 3rd-degree felony. And so,
Yeah, 69 days, and see how that started to take shape.
yeah, we'll set this for status on October 29th. And Mr. White, you are retained on that case, is that correct?
Yes, sir, I am. Yeah, but I have not.
Okay.
But they sent me one this morning on this case.
Your Honor, I had looked up. I tried to pull them over. He didn't look. He said, had a quick thought, previous authorities. I think we got one.
All right, are we ready for Ms. Jones? Yeah, we're gonna get that set up. Do you have any other clients? Let's see, who else do we have in here? All right, this is cause number CR 24-24, State of Texas versus Tammy Diane Jones. And I understand that we're set for a plea today. Is that correct, Mr. White?
Yes, sir.
And you have disclosed to the court that Ms. Jones is legally deaf. Is that correct?
That's correct.
And that also that Ms. Jones does not use American Sign Language or any other sign language in which the court could provide an interpreter. Is that correct?
That's correct.
You've also indicated to the court that Ms. Jones has functioned throughout her life with the assistance of family members who have established a language, a sign language of sorts that is known only to them. Is that correct?
That's correct.
However, you have also indicated to the court that Ms. Jones is capable of reading and understanding the English language. Is that correct? And so do you believe, Mr. White, that if the court provides an accommodation today in which Ms. Grisham is actively transcribing what's spoken in court onto a screen in which Ms. Jones can read, that will accommodate her to the degree that she can understand everything that's happening in this proceeding today?
Yes, sir, I'm satisfied on that. Just so the court knows, we went over the plea papers. Ms. Jones' sister, Wendy Bassett, was in the room. I spoke with the record of both of them. And of course, I hope that Ms. Jones could read my lips, but also with Ms. Massey there so she could explain anything that we had and related questions. And then they also both read the paperwork as well. So I'm satisfied that we've taken every caution to make sure that Ms. Jones understands what her rights are, that they have not been infringed, and that she also understands the nature of what we're doing here. I have not actually had, other than the obvious issues with her being hearing impaired, I do not feel I've had any difficulty in relaying anything that I've had to relay to. I felt like that she got the message to help Ms. Massey.
And do you believe that Ms. Massey will be able to assist Ms. Jones in complying with her conditions of community supervision?
I do.
Ms. Jones, do you understand everything that's been said to you today? All right, so Ms. Jones, I'm going to have you raise your right hand. Ms. Jones, do you swear that the testimony you given to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, for the record, the court finds that Ms. Jones has answered in the affirmative. Ms. Jones, you can lower your hand. And Ms. Jones, if you need to read the screen, if you have difficulty reading my lips, you can read the screen and look back to me. There's no, disrespect in that, okay? So we're making this accommodation for you if you need it. All right, Ms. Jones, are you a United States citizen who reads, writes, and speaks English? And there will be a little bit of a delay in what I say and when she can write it and when it can be on the screen. So take your time. All right. Ms. Jones, have you ever been diagnosed with any type of mental condition? Mental condition like schizophrenia or PTSD? All right, court's finding that Ms. Jones has answered in the negative. And Ms. Jones, in this case, you've been represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the work he's done for you? Do you have any questions about? Oh, okay. All right, the court finds that Ms. Jones has indicated that she is pleased with Mr. White and his representation. Ms. Jones, do you understand everything that you have read and signed today in your plea agreement? And she's answered in the affirmative. And Ms. Jones, do you have any questions before we go further? All right, and the court finds that she has answered in the negative. All right, Mr. White, do you believe Ms. Jones to be competent today to enter into this plea agreement?
Yes, sir, I do.
And have you explained to her her rights as they pertain to this case?
Yes, sir, I've explained to Ms. Jones the rights as they pertain to this case. I believe that she's waived those rights knowingly, voluntarily. I would also note to the court that we're asking the court to go along with a deferred adjudication. I've explained to Ms. Jones the advantages and disadvantages of entering into such an agreement with the state of Texas. I'm satisfied that she understands that. Most notably, I've explained to her if she should complete this, that the case will be dismissed against her, but it will still show us an arrest on the record. If she does not complete, which violates the statement filed a motion to revoke the probation and seek adjudication. And if it's shown more likely than not that she did in fact violate the probation, or could revoke the probation, and then sentence her up to 10 years in the Texas Department of Corrections, then it's a $10,000. Satisfied that she understands that and will be entering this plea voluntarily.
And Ms. Jones, do you agree with everything that Mr. White has said today? And the court finds that she is answering in the affirmative. All right, Ms. Jones, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1 between 1 grams and 4 grams. The range of punishment for that offense is confinement of not less than 2 years in prison or more than 10 years in prison, and a fine not to exceed $10,000 if you were to be convicted. The plea agreement in your case is upon your plea of guilty, the state is recommending to the court that the court not convict you of this offense, but rather place you on deferred community supervision on a lesser included offense of possession of a controlled substance in penalty group 1 between 1 gram and 4 grams, with your punishment being suspended and you being placed on 5 years community supervision. In addition, you would be responsible for a $1,500 fine, court costs of $290, reimbursement fees of $35, and restitution for the testing of the substances in this case of $180. Is that your understanding of the plea agreement, Ms. Jones? All right, court finds that she has answered, it is affirmatively that it is her understanding. So at this time, Ms. Jones, I would ask you, how do you plead to that crime? Are you guilty or not guilty? All right, court, go ahead, Mr. White.
He didn't pay me guilty. That's
All right, court finds that Ms. Jones has answered in the affirmative with regards to guilty. Court, and Ms. Jones, has anybody threatened you, forced you, or pressured you to plead guilty to this crime? All right, court finds that she has answered in the negative. Ms. Jones, the court will accept your plea of guilt at this time. Mr. White, any objections to the stipulation of evidence?
no, sir, we don't have objection.
All right, the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further. Your Honor. Thank
Is there anything further from the defense?
No.
All right, the court will review the evidence at this time. Okay, the court reviewing the evidence finds that there is enough evidence to convict Ms. Jones of this offense. However, the court will defer a finding of guilt on the third-degree felony offense of possession of a controlled substance between 1 gram and 4 grams, penalty group 1. The court places her on community supervision for a period of 5 years, orders her to pay a $1,500 fine, restitution of $180, court costs of $290, and reimbursement fees of $35. Ms. Jones, you are hereby remanded to the custody of the probation department. They will give you more information in just a few moments. I'm going to sign the paperwork. I'm going to give it to Deputy Martinez and he will take your fingerprint and then they'll give you more information. And ma'am, what's your name? All right, and Miss Massey, whenever she goes back with the probation department, you're welcome to go back there and assist, okay? And Mr. Hartwell, I'm gonna need you to sign some of these paperwork here.
Yeah.
No, sir. That one right there, and then you can give it to Fabio to fingerprint.
Honor, that is,
I don't know.
yes.
All right, let the record reflect that the names of Jamich. I don't know. James Treese Turner Benson and Krista Levon Hastings and Darian Dwayne Dotson were all ordered to be in court today. Court they've not been present. The court has had their name called loudly, distinctly 3 times in the courthouse with no response. With regards to Darian Dotson, Mr. Schmidt has indicated to the court that Mr. Dotson contacted him as counsel and indicated that he's had automotive issues in that he's trying to, that maybe he's in Shreveport, Louisiana. Mr. Schmidt having indicated to the court that he's communicated to Mr. Dotson that he needs to be here by 5 p.m. The court will take the NISI under advisement until 5 p.m. or until further information is provided to the court. With regards to Demetrius Benson or Krista Hastings, the court is issuing a judgment nisi and alias capias in each one of those cases. That does conclude this morning's criminal docket. Court was going to stand in recess until 1:30. Yep. One last case, court had Ms. Belinda Norman set for pretrial noncompliance in a pretrial supervision case. Court finds that Ms. Norman is in custody in Terrell State Hospital, having been committed July 16th, 2024, with no expected date of release. Court will not be hearing Ms. Norman's case today. Court is in recess till 1:30.